Hello students, my name is Aditya Gupta and I am a lawyer at the Delhi High Court. Today we will be studying the module on the limitations on the rights of trademark owners. By the end of this module, I hope you will be able to understand the defenses that a person who is sued for trademark infringement can take and the various sections which are provided in the Trademarks Act for this purpose. Let's first go on to Section 30 Clause 3, which deals with the doctrine of the exhaustion of rights. Let me start by giving you an example. Let's say you go to a store to buy a printer of a multinational company, and then your colleague asks you for a resale of that printer and offers you a great deal. You decide to sell the printer to him, but then you're worried, will the sale of my printer, the printer that I have bought, amount to an infringement of trademark? Section 30 Clause 3 deals with this kind of an issue. It deals with the doctrine of exhaustion of rights. What do I mean when I use the term exhaustion? Exhaustion means, do the rights terminate or exhaust after the goods which bear that trademark have been sold for the first time. This is why this doctrine is also called the first sale doctrine. So the question to be asked is, do trademark rights continue to exist after the first sale of the goods? Also remember, when we are talking about the exhaustion of rights, it is only about exhaustion of rights in a particular set of goods, not across the goods. Therefore, even if the answer to your earlier question was in the affirmative, that is, you could sell the printer to your friend, it would not mean that the trademark rights of the trademark proprietor would be exhausted with respect to all printers. It would only mean that the trademark rights would get exhausted with respect to that particular printer which has already been sold to you. Now let's try and understand the different intricacies involved in the doctrine of exhaustion of rights. There are two types of regimes. One is national exhaustion and the other is international exhaustion. What do I mean by these terms? Well, it is important for you to first understand that the laws in most countries, including the law in India, recognizes that there needs to be some sort of exhaustion. That is, whether national or international. The debate really revolves around the geographical extent of exhaustion of rights. Let's deal first with the doctrine of international exhaustion. If the doctrine is considered to be one of international exhaustion, then goods bought anywhere in the world would lose their trademark rights in India as soon as the first sale is made. So, for instance, you bought a printer in Singapore and then imported the same into India and then sold it to your colleague in India. That would mean if the doctrine of international exhaustion is adopted, that sale would not be trademark infringement. Of course, it is important to remember that when we talk about exhaustion of rights, it's not usually with respect to an individual consumer like you. Many businesses are based on this business model wherein goods are bought in another country where they're sold at a cheaper rate and then imported into India and then sold in India. And that is why this doctrine becomes relevant, because it is not only about individuals but about businesses. Let's now go on to the doctrine of national exhaustion. If India adopts the doctrine of national exhaustion, then we would say that the printer purchased in Singapore cannot be sold in India without the consent of the trademark proprietor. However, a trademark bought in Bombay can be sold in Delhi without the consent of the trademark proprietor. Therefore, national exhaustion means that the geographical extent of the trademark rights would be limited to India, and a proprietor does not lose trademark rights when the goods are bought in other countries. The big question is, does India follow international exhaustion or national exhaustion? The relevant provision that you need to look at for this purpose is section 30 clause 3. Unfortunately, the section itself does not really specify whether India follows national exhaustion or international exhaustion, and therefore we are left to judges to interpret the intention of the legislature and come up with this really important answer. The Delhi High Court has dealt with this provision in the Samsung versus Kapil Wadhwa case. The single judge of the Delhi High Court, Justice Manmohan Singh, held that India follows the rule of national exhaustion. In this case, the Delhi High Court was considering the question whether goods imported by the proprietor, by the defendant from abroad, can be sold in India without it being considered infringement of Samsung's trademark. The goods involved in this case were also printers, and they were being sold commercially by the importer who had got the goods from abroad. Also, it's important to note that these printers were being sold at a much cheaper price as compared to the price at which Samsung is offering its printers in India. The Delhi High Court decided this matter in two phases. First, at the lower court level, a single judge of the Delhi High Court, Justice Manmohan Singh, decided this issue and held that by a reading of section 30 clause 3, it seems that India follows the principle of national exhaustion. He relied on the decisions of many countries and also looked at several policy considerations before reaching his decision. He also acknowledged that the statute by itself is not very clear. That is, section 30 clause 3 by itself is not very clear as to whether India follows the doctrine of national exhaustion or international exhaustion, but by reading several other provisions in the statute, he came to the conclusion that India does follow the principle of national exhaustion. Therefore, the defendant who was selling goods which were bought from abroad was liable for infringement of trademark, since Samsung did not lose its rights in the goods which it had sold abroad. The defendants went in appeal against the decision of the single judge. The appellate court, that is a two-judge bench of the Delhi High Court, decided that India follows the principle of international exhaustion. They said that because of the statement of objects and reasons, it seems that the legislature intended that India follows a principle of international exhaustion. Therefore, the court held that the defendant must be exonerated of all liability if it buys goods abroad and then resells them in India. The case is currently pending before the Honorable Supreme Court, and this is one case which all trademark lawyers are really watching out for. As a student, I would recommend that you also watch out for this case and do read it when the decision is passed by the Honorable Supreme Court. Another interesting question: apart from the legal arguments, what is more beneficial from a policy perspective? One thing that you may remember from my earlier lecture is that the printers being sold by the defendant were cheaper as compared to Samsung's printers. This means that sometimes following the principle of international exhaustion can prove beneficial to consumers. But unfortunately, this is only half the story. You must also remember that it is important for a trademark owner to be able to regulate the channel of goods through which the goods are sold. It is important for a trademark proprietor to be able to regulate the channel of goods through which its goods are sold. Let me tell you the reason why. This is because a trademark proprietor does not only sell the goods to the consumer, it also provides after-sales service, warranty and other services to its consumers. This means that if there is any defect in the goods and the trademark proprietor is not able to offer warranty or after-sales service because it was not through the regulated channels, the consumer would end up blaming the trademark proprietor, and this would mean that the value of the trademark will diminish because consumers will feel that the goods of a particular trademark are not as worthy as they seem. Let me take the Samsung versus Kapil Wadhwa example. Let's say a consumer goes to the defendant's shop and buy a parallelly imported Samsung product. Because Samsung offers regional warranties, it would mean that a good purchased in Singapore will not be offered warranty in India. This would mean that the person who buys the printer from the defendant in India would not be able to avail the warranty on the Samsung printers in India. Therefore, if there is any defect in the Samsung printer or if the consumer needs any after-sales service and if he is not able to get it because of this difference in regional warranty, the consumer would not blame the defendant. The consumer would in fact blame Samsung, and Samsung's brand value and trademark would both be diluted. This is why, while trademark exhaustion does allow consumers to buy goods cheaply, it may also in certain cases cause harm to the trademark proprietor, and this is why companies like Samsung and many other companies who operate internationally are hoping and are looking towards the Supreme Court towards holding that India follows the principle of national exhaustion. Let's wait and watch and see what the future holds.